Thank you for joining us today. My name is Jeff Landau, and you can see my guest is Richard Sperling. I'm grateful to be able to call Richard a friend of mine and also an expert in his field, both in real estate and in the family law space. Richard's practice, for those of you that don't know him yet, Richard's practice focuses on divorce, premarital agreements, post-marital agreements, in case you didn't know that was even possible, and Marvin palimony claims. And he also mediates divorce cases. Before going into family law, he was a real estate and business attorney and operated a multi-office escrow operation. He was also appointed as the attorney for housing and urban development in the Northwest United States. He has taught business law and real property at Cal State Northridge and negotiation and mediation at the graduate and law school levels. He's also a certified mediator, having trained at the Strauss Institute at Pepperdine. After years as a business and real estate practitioner, he pivoted into family law, and now his practice emphasizes agreements and peacemaking, which I didn't know that family law involved peacemaking, but I'm glad that that's your approach. And finally, when he's not in the office, you can probably find him at the landing in Westlake at Bonnaby, either having a coffee and half hot chocolate, or on his sailboat or playing guitar. Welcome, Richard.
Thank you, Jeff. I hope to have a sailboat someday, but you know, peacemaking, you do a lot of peacemaking in your real estate practice, because when you get sellers and buyers together, or you're dealing with an agent and trying to put a deal together, you're using the same techniques and strategies we use when we mediate and negotiate divorces, because you have people with different interests and goals, and you need to bring them together and get a deal put together. So I've seen you in action, and you are a good negotiator, and you're a good mediator too. So
Thank you.
So we have those in common.
We
And
absolutely do.
We both need a sailboat. So
I'd love to get on the sailboat with you, as long as you don't need me to do much, because I'm usually just eye candy when I'm on a sailboat.
You're a good crew.
I can crew. Before getting into some questions that I have prepared, I wanted to touch on something that you just mentioned in this overlap that you and I have when we're dealing with what we do on a daily basis. And there's a way to approach, with me, buyers and sellers, with you, opposite, opposing parties, for, I don't know if I'm saying it the right way. And you and I can approach that from a logical standpoint, fact, logic, and reason, or we can approach it from the emotional standpoint. Do you find your mediations and trying to keep the peace and find a mutual ground for both parties? Do you find that from a fact and logic standpoint, or do you find that when you're mostly dealing with their emotions?
It's a great question, because as a divorce mediator, what I've seen is that there are some people out there who are great mediators who don't have any training in mediation or negotiation at all. And there are some terrible mediators who have gone through a lot of training, both legal training and mediation training, but they're just not good at bringing people together and peacemaking. So it does seem to be a little bit of an inherent talent. I'll tell you how I got into it. I had these escrow offices throughout the Northwest. I was a real estate attorney and had these escrow offices because in Washington State and in those areas, the attorneys handled all the escrows. An escrow is when a seller and buyer go into a third-party office, have them handle the money and prepare the documents and record the documents and transfer title from seller to buyer. So when I would open an office, I would hire escrow officers, and they would they would handle all the technical and escrow operations. They would sign the seller and buyer the documents these people would normally sign in person. And so my job evolved into, I'd get a phone call, and the phone call would be, well, our seller or our buyer or our realtors are not in agreement. Can you arrange to come to our office and meet with the seller and buyer and maybe the real estate agents and try and get everybody to agree so the deal can close, so the escrow can close. So for many years, I was traveling all throughout Washington to these offices and having these conferences with sellers and buyers and realtors and getting them to come to an agreement and keep the deal together. And over the years, I probably did hundreds of these. Years later, when I went to the Strauss Institute at Pepperdine in Malibu and went through a formal mediation course, I realized that I had been mediating for all those years and that I was a relatively experienced mediator. And part of the reason I pivoted into family law and into peacemaking and mediation and putting all these premarital and post-marital agreements together and resolving divorces is that was who I am. That was a good fit for me. And that's why the pivot was a natural one. I realized I enjoyed working with people and bringing them together instead of working with contracts. But to answer your question more specifically, there's a great book on mediation called Getting to Yes. And it's written by professors at Harvard, and they originated kind of the formal mediation training process. Mediation is really getting people to come to an agreement. And Getting to Yes emphasizes some practices that maybe we could say are emotional. And the practices center around some concepts. One concept is helping people to exercise what we call active listening, which is listening to what the other person says and acknowledging that you've heard what they say and that you understand it. And another part of Getting to Yes is having people not just say what their position is, like, I want the Ferrari, or I want to pay only $1 million for your house and not $1.1 million. But Getting to Yes emphasizes the reason for your position. Explain the reason for your position so the other person or people can understand your position. So those are two bases for helping people to come together. Sometimes a particular statement is helpful, sometimes an apology is helpful, but I guess you could call that an emotional negotiation. Sometimes it's just telling somebody why you feel the way you do, or the position, why you're taking the position you do. But I guess we could call it emotional. Some people call it emotional intelligence. I know you practice that when you sell real estate. You're not only very knowledgeable about the market and very knowledgeable about how to prepare a house for selling and where to price it at, but when you meet with a seller or buyer or the other realtor, I know you, Jeff, you practice these techniques yourself to get people to come to an agreement. And part of this, I think, is that when people come to an agreement after having an ability to talk about it, they have kind of a stake in their agreement. They have an involvement in coming to an agreement, but they also feel good about it. And it's really nice to put an agreement together where people walk away and they feel okay about it. There's a joke that, well, how did the divorce go? How did you come to an agreement? Well, both parties feel equally unhappy, so we were able to put a deal together.
Exactly.
But these days, what we're really striving for is both parties being knowledgeable about the deal they've made or the agreement they've made, and hopefully they come away feeling good about it. And you know, I've got a case right now where people listed a house for sale, and a husband and wife in a divorce. 2 months passed, and now the listing agent has asked both parties to reduce the listing price from something like $1.1 million to 900,000. And they're both very unhappy, because they don't understand why the real estate agent felt so good about listing the house at 1-1 only 60 days ago. And now the real estate agent wants to lower it down to 900, where the market really hasn't diminished significantly in 60 days. But you know, that's an example of people that trying to make a deal, trying to get them to agree to a price reduction, but they don't feel good about it. And I see in your practice, your clients are happy. So that's good to see for you.
Certainly try. Certainly try. And if we went down what I'm going to say next, we'd go into a rabbit hole and completely pivot from what our purpose was today. So we're not going to. The funny thing is, as much as you and I bring emotional intelligence to our clients, we're studying with Chris Voss, who is a former lead international hostage negotiator for the FBI. He wrote a book, Never Split the Difference. Part of his training was based on getting to know as opposed to getting to yes. Mm-hmm. So again, we're not going to go there. I would love to, not on this one. So let's get into a couple of questions that I have, and you can let our audience know maybe just a little bit of what can be expected-ish during a divorce. So if you have a husband and wife, they could sell personal property, right? You like guitars, you could sell that. You could sell a car.
Until a divorce is filed. It's interesting in California, one of the reasons for filing, you know, people say, you know, should we file, should we not file? One of the reasons for filing is the court issues an automatic restraining order applicable to both spouses immediately upon filing, which says, you know, in normal circumstances, we know you cannot sell real property unless both husband and wife join signing the deed. But a restraining order is sent out by the court, which says you can't change the status quo because a divorce has been filed. You can't sell or give away any property. You can't cancel or change any insurance policies. You can't fund a new trust or will. So a lot happens when something is filed. But until then, yes, I can go ahead and sell one of my guitars. I can give away my wife's sewing machine while we're married. I can do that. But you know, if it damages the community, you know, if we have a Ferrari and I give it away, then I'm responsible for paying my wife half the value of the Ferrari if I gave community property away. And certainly I can't give the Ferrari away or even sell it if it's my wife's personal property. We have a community property system in California where whatever we own before the marriage is my separate property. Whatever I receive during the marriage by gift or inheritance is my separate property. But without a premarital agreement, whatever we earn or acquire during the marriage, we own 50-50, and one spouse cannot give away or undersell any community property.
I would imagine part of that depends upon if it's community property or community property with right of survivorship.
Well, actually the community property right of survivorship agreement that we might put together is meaningless. The survivorship part is meaningless until somebody dies. So while we're alive, we can still deal with community property as if the survivorship agreement didn't exist. Just like a will, I might put in my will that when I die, I give Jeff Landau my Taylor guitar, my new 814 Taylor guitar. But even if I put that in my will and trust, while I'm alive, I can give or sell that guitar to somebody else.
And the right of survivorship, I was under the impression that right of survivorship automatically goes to the spouse, but if there's no, well, and this is only with regards to real estate. I don't know how it affects personal property. That with real estate, if the home is only husband and wife as community property, then either party can still do what they want with their half. Is that accurate?
That's a very interesting point. You know, for non-spouses, we get into the differences between joint tenancy with right of survivorship and tenants in common. Um, there's a third way to hold property in California, and that is as community property. If we hold property as community property, I cannot sell my half. So if my wife and I, or my partner and I, buy a house together and it's community property, I that property is part of the community. I cannot sell my half to somebody else because
Could
it's
you,
part of that marital community. Whereas Jeff, if you and I go into partnership and we buy a rental, if we own it as tenants in common, I can sell my half to anybody I want. But if we own it as joint tenants with right of survivorship, just as partners and as buddies, I can't sell my half.
what about a husband and wife owning as community property, not with right of survivorship? They own a house, community property, and one of them passes. Could they have left their half to somebody else?
Yes, it's
Okay.
big part of estate planning
Okay.
when spouses pass. Let's say I'm married and we own our house together. When I pass, if we own the property as community property with rights of survivorship, then I'm committed. And if I die first, then my wife inherits the entire house. But if we own our residence as community property, not as community property with right of survivorship, then when I die, I can put in my trust or will that I want my half of the house, my community property interest, to go to whomever I want, whereas my wife or my partner is going to inherit his or her half of the house because they own half the house. And that's an important part of premarital agreements and post-marital agreements also. You know, in a premarital agreement or post-marital agreement, well, let me say it this way. I might be married and I might say to my wife, don't worry, dear. When I die, I will take $1 million for my separate property and I'll make sure it goes to you. Or, you know, that rental I owned before we were married, I'll make sure it goes to you. I can say that and I can go to my estate planning attorney and provide that in my trust or will. But it's really important to note that that is not a promise that's binding. I can go back the next day to my estate planning attorney and I can tell her, I want to rescind my trust. I want to void it. I want to modify it. I want to leave that rental to Jeff Landau. And I can do that because a trust or a will is not a binding instrument. Whereas if I say to my wife, I will leave that rental to you, or I'll leave $1 million to you, my wife can say, oh, honey, that's great that you make that promise. Now let's go to an attorney and put together an agreement. If we're not married yet, a premarital agreement. If we're already married, a postmarital agreement. And let's put that promise in that agreement. And if we do that, it becomes a binding promise that's binding on my estate. So a lot of times we use a premarital agreement or a postmarital agreement as an estate planning tool.
And I got us a little sidetracked with an estate planning tidbit.
I love your tidbits.
Thank you. When a couple is in the divorcing process and they own real estate, is there a certain process how, and this is going to sound self-serving, but I'm just curious, is there a process when one person wants to hire a real estate agent where the other person wants to hire another one? And I'm sure when it gets contentious, because it seems to happen every time, there's a finger gets pointed, oh, you want to work with them because you're getting a kickback. How does that, is there a legal way that has to get handled, or is it an informal way of when they both butt heads on who to hire to sell the house, how that gets handled?
Well, You know, the big issue is a lot of times one spouse will say, I don't want to sell the house. The kids have grown up in the house. I'm here in the house. It gives us security. We love our house. This is where our friends are, our children's friends are. I don't want to sell. And the other spouse who maybe has moved out or been kicked out says, well, you know, we've got a $600,000 equity in our house and I need my half. I need my 300. I need that now because I want to go buy a condo. I don't want to be in this apartment. So the question becomes, can we force a situation on a spouse where we're not going to sell? And the answer is, if you get to the courthouse, the judge is, and you can't agree, and we get in front of a judge, the judge is going to order the house to be sold. And the judge will give one spouse or the other the power of sale. The judge will say, okay, wife, or okay, husband, you can pick the realtor. You and the realtor can pick the sales price and go for it. So there are situations where we can say, well, a sale of the house now would be traumatic for the kids. Let's delay it for a few years. Let's delay it till the children graduate high school. But without that dispensation from the judge, the house will be sold right away. A lot of family law lawyers fail to provide for the disposition of the house, the details, when they resolve or negotiate a settlement to a divorce. So I see a lot of people where they're divorced and there's no resolution of who gets to pick the realtor and who gets to pick the sales price and who gets to pick the escrow company and so on. So I think it's important to tend to that when people separate or when they file for divorce. Selecting a realtor and getting the house sold is just one of the terms that they need to come to agreement on, and it's a very important term because usually the house is their most valuable asset. So a family law attorney should handle that right away. You know, who's going to be able to live in the house if they're not both living there? Who's going to pay the mortgage payment? When are we going to sell it? And when we sell it, what are the terms? So we don't have to come back to court, or we don't have to pay a lot of lawyers money because one party wants Jeff Landau to be the realtor and the other party wants a different realtor to be the realtor. So it's good to resolve that. Luckily, there are some realtors in our community like you, Jeff, where you're well known and you're known to be fair and honest. And when it comes time to say, well, let's list with Jeff Landau, we usually the husband and wife say, oh yeah, we've heard of him. Okay, great.
Thank you.
You're welcome.
If a couple separates, one of them gets sued, and with them being sued, there's a judgment. Can the judgment become a lien on the residents so they can't sell without the lien getting released, even though they were on the path to getting divorced when that happened?
Usually, once you've separated, once you can prove that you've really separated from your spouse, if your spouse incurs the liability, then that will become it might become a lien on the house before the house sells. But usually we can restrict exposure to paying that lien to only the half of the proceeds that are owned by the spouse that incurred the liability. A problem we have in divorces is I might have a joint checking account or a credit card with my spouse, and I've entered into a contract with, let's say, B of A. Well, okay, we have this credit card, we have this checking account, and both of us are responsible. So if either of us writes a check or either of us makes a charge on the credit card, we promise B of A to you that we'll be liable for it. So let's say we file for divorce, we separate, and I go to Vegas and I have a big bill after the weekend. B of A can say that that's a joint obligation because that's our contract with B of A. But on the other hand, if my wife and I or my partner and I really separate, we live apart, we don't have joint finances anymore. My paycheck goes into my own bank account. We're really separated. And I enter into a contract and breach the contract, or I get into a car accident and cause damage, then the rule is that only I would be responsible. The problem is that the creditor can lien the house if they get a judgment, and that complicates the sale of the house. We may have to go to a judge to remove the lien, and we may be able to remove the lien only by paying the lien off. But between the spouses, the law is clear that only the wrongdoer will have to pay. But the creditor can probably put a lien on the house. And for that reason, that's a major reason why when we file for divorce, I say, first of all, let's file and let's show the world that we're separated. And secondly, as part of filing now, let's segregate our bank accounts and our credit cards. Let's segregate our insurance policies. So let's make sure that if your spouse goes to Vegas and runs up a bill or runs over somebody with their car, that you're not going to be responsible and we can get you out of that jam. So it's an important reason to file, an important reason to separate your finances and make a change with your joint credit cards and joint bank accounts.
So
I should say,
I'm sorry.
that there are some obligations that we're just going to have to face as joint. So for instance, if we're married and then we separate and I'm going to give the house to my wife, but we owe the IRS money and the IRS files a lien, that's an example where that lien is going to have to be paid off in full.
It's not going anywhere.
What?
That's not going anywhere.
No, and there are also some liens that are very difficult to remove. If I was married previously and I owe child support or spousal support to a former spouse, and that becomes a lien, that's going to be difficult to deal with.
You had mentioned earlier, is separation something that you would file? You could file
Well,
for separation?
no, when we file for divorce, we want to take the next step.
Okay.
I mean, if we file for divorce and we're still living together and we're still having joint bank accounts and our labor and our income and our paychecks are going to a joint account, we really haven't separated yet. There's no final break. And in that case, I may be still responsible for my spouse's financial activity. So we don't file anything to show that we're separated, but we file for divorce and then we take the next step, which is let's show the world and potentially the judge that we've really separated. There's a final break to our lives. We don't have joint bank accounts anymore. We don't live in the same house anymore.
Got it. So when a couple is married and they say we're separated right now, that's nothing formal with the courts. That's them taking some time away to try to figure things out then.
Right. That's
Okay.
a very difficult and important legal point in a divorce, because if I file for divorce and I'm not separated yet, my income is still community property. And if I deposit funds into an IRA or a 401k, those deposits are still community property. Whereas if there's a final break and we're not living together and we don't have joint finances anymore, and we end up in front of a judge, the judge would agree, oh yes, that's your date of separation. You filed January 10th. And you did separate January 30th. I can see that your bank accounts were closed. I can see your credit card got canceled or assigned to one spouse or the other. So the date of separation becomes very important because my income and your income becomes separate property once we've separated. There's another concept that we should talk about, and that is a filing for a legal separation instead of a divorce. And I'll just say really briefly that is a different kind of thing. That is, for religious or emotional reasons, I might decide to file for divorce. I should say to file for legal separation. And a legal separation means we go through dividing the assets by court order, dividing the debts by court order, dealing with support and custody and visitation of kids and pets. And then there's a box at the bottom of the page. And that box, if it's checked, says, I, the judge, now terminate the marriage. You're no longer married. You can marry somebody else if you want. This marriage is over. And when we file for legal separation, when we get to that point after a 6-month required waiting period, in a legal separation case, that box is not checked. So everything is resolved except we're still married. As we go into the future, we have to go back to court in order to get a divorce. Whereas in a divorce, the judge checks that box and our marriage is also terminated.
Got it. So there's this thing called a common law marriage. And that, my understanding is that goes state by state. Does California have this common law marriage? And if so, what is it? And what is it not if we don't have it?
There's no common law marriage in California. Common law marriage says, well, if we've been living together for a certain number of years, like in Idaho, I think it's 7 years. There are only 7 or 11 states that have common law marriage. That means that if we've been living together, we're going to be treated just like husband and wife. Whatever we acquired is going to be community property. And if we split up, I'm going to have an obligation to support you if I've made more money than you during the marriage. That's common law marriage. It's just that there is no common law marriage in California. So if I decide not to marry and my partner and I simply live together, then potentially there's no benefit if we split up to each other. There's not going to be any sharing of assets. There's not going to be any support paid. Now, there is a case that came from a case involving the actor Lee Marvin, where he met a young lady on the set, moved in with her, lived with her, and then they split up. And when they split up, she went to court and alleged that he promised to support her for the rest of her life. And he promised that whatever he earned while they were together was half hers. And the court said, okay, when you live together, there's no common law marriage and you don't automatically have any community property. You don't automatically get a share of any property or any support. But if you, after you break up, if you come to court and you convince a judge that there was a promise, even a verbal promise, to pool assets, to own assets jointly, or a promise of support, the judge can enforce that promise, and it's called a Marvin palimony claim. They're difficult to prove, but they're very scary. And for that reason, when people live together, we recommend that they have a cohabitation agreement that resolves whether or not there's going to be any Marvin support or Marvin pooled assets. And even in a premarital agreement or a post-marital agreement, we recommend that we address the Marvin palimony claim possibility. So in a premarital agreement where people have been living together, we will say, here's what we're going to do regarding property, regarding support. And by the way, we did live together, but we agree that there were no Marvin promises made while we were living together. So that's one of the reasons why a premarital agreement can be very important. But there's no common law marriage.
So it seems like it would not be wrong to assume that premarital agreements are completely enforceable like any other written contract.
That's true. But there is a statute that governs how to make a premarital agreement enforceable. So a premarital agreement has to be somewhat fair to both parties. A premarital agreement has to be in writing and the signature notarized. Each party should have their own lawyer, and if spousal support is limited or waived, each party must have their own lawyer. And from the Barry Bonds case, once we have a draft of the premarital agreement ready to sign, each party has to wait at least 7 days before they sign the premarital agreement. Barry Bonds was, as you know, a famous baseball player. He fell in love with a Swedish hairdresser who barely spoke English, and they decided to get married. And on the morning of their wedding, when at the hotel that they were staying at, Barry sent his lawyer down into the lobby to meet with his future wife. And his lawyer had a premarital agreement in hand and said, okay, I want you to sign this premarital agreement. And she said, I don't understand it. And I just saw it and I don't want to sign it. And we're getting on an airplane going to the destination wedding in an hour. I don't want to sign this. And the lawyer said, sign it now or there's no wedding. And she said, but I have 70 people here from Stockholm to attend the wedding. How can I, what are you doing? Anyway, she signed the premarital agreement and it provided that Barry would not have to pay her any spousal support. And they got married, and later his salary went from 106,000 a year to 26 million a year. And then he dumped her, and the court enforced the premarital agreement and said, sorry, you signed it, too bad. And from that, we have this statute that says the agreement's got to be somewhat fair. Each party should have their own lawyer, and you have to have the agreement in hand 7 days before you sign it. So with provisors like those, yes, premarital agreements and postmarital agreements are enforceable in California. And if you don't have them, then the real premarital agreement you're stuck with is the family law statute. And the family law statute is lousy. And that's in terms of protecting people. That's why divorce lawyers make so much money, is because without a premarital agreement, there's so much opportunity to argue about things like, well, what's community property? And what promises did we make? And what is fair spousal support? And who made what during the marriage? And who established a standard of marital standard of living during the marriage? And people pay their lawyers hundreds of thousands of dollars to resolve their divorce, where a simple premarital agreement or even a postmarital agreement would have resolved all those issues. And with half the marriages ending in divorce, we see that a premarital agreement or a postmarital agreement are really important. Luckily, these days, people don't feel awkward or offended when we talk about a premarital agreement or postmarital agreement. I can remember years ago, people would say, well, what's the problem? Don't you love me? Don't you trust me? But these days, people realize that well, it's first of all, it can be romantic. We can show each other we love each other in this premarital agreement. And I, as an attorney handling them, we do keep them simple and romantic as much as we can. But it is an opportunity to say, let's go into this marriage and set aside these issues. Let's resolve them and set them aside and never think about it again.
So that's probably the biggest pushback I would imagine that you get from either side. That, oh, how could you be bringing up this business thing when we're in love and we're getting married, and now you want to talk about what's going to happen when we're not married anymore? So just from your own personal experience, however many years you've been handling pre and post-marital agreements, how many times has it come up where the marriage got called off because of somebody wanting to sign a premarital agreement?
This is really interesting because years ago, a lot of people did business by a handshake. And especially in America, there are some real characters that they want to do business by a handshake. Here, I'll do this deal with you. What? You want me to do a written contract? Don't you trust me? Let's just shake hands on it. And maybe 50 years ago, that was very common. These days, a smart business person is not going to enter into a real estate transaction or a business transaction that's verbal. I mean, that almost it happens in the movies, but it almost never happens because our business acumen, our real estate acumen has evolved, and we see that it's so important to put things in writing. And the same is true for premarital agreements and postmarital agreements. It used to be years ago that people say, what do you mean? You don't trust me? And some lawyers, if you go to the wrong lawyer for a premarital agreement, a lawyer who wants to make a reputation or wants to make a lot of money, or is just a contrary person, or maybe is not competent, the wrong lawyer can make a premarital agreement difficult, but good lawyers, just like a good surgeon, can give you a better chance of having a surgery go successfully. A competent, experienced family law attorney can help you with a post-marital agreement or a premarital agreement and keep it simple and romantic and explain, well, we're doing this in the premarital agreement for this reason. Oh, I understand. Okay, I understand. So an example, let's say one partner wants to provide for the other partner money if they divorce. So might say, I wanna provide for you something like $10,000 a year. I mean, if we're married for 5 years, I wanna give you $50,000 so that after our marriage, if our marriage isn't successful, you're okay. Now, if the other person says, well, I want you to give me the $50,000 the day after we're married. Well, that really doesn't take into account, well, what if we're married for a week? And then our marriage doesn't work. Should I still pay you the 50,000? So there are opportunities to explain the reasons for our position in a premarital agreement to assure the other person that, hey, if we're married 5 or 10 or 20 years, or if I have your children, we can go into the reasons for our positions and have a fair premarital agreement. And when our terms are fair, usually the people say or realize, yeah, this is a good idea. Let's resolve all of this so we don't have to argue about later.
So it sounds like it doesn't really prevent any marriages from taking place.
Thank you. Let me answer your question. I've been doing this 20 years. I've done hundreds of agreements, and I've never seen a marriage not take place because of premarital agreements or premarital agreement negotiations. I've never seen that.
So 20 years, hundreds of agreements, and never one time did it stop people from getting married. So hopefully that helps people get over that hump of what's the other person going to say.
Right. And I hope you would say the same thing, Jeff, that you've been selling real estate for 20 years and you've put hundreds of deals together and you've never seen a seller fail to sell their house or a buyer fail to buy a house. Some deals don't come together, but I'm sure that in your situation, you've kept your deals together pretty much.
True. So if you have a couple divorcing where one spouse stays in the house, they're awarded the house, and then whenever they sell, they obviously have a capital gain. And I don't know if this is going to be too much of a tax question, but I would imagine that you're very versed in this. How did the taxes get allocated to both spouses?
Thank you for suggesting that I'm very versed. That would be there's a song in there somewhere. The day I was very versed.
Can you play it for us?
I would like to write it. It's a classic. I teach community property at a local law school, and one of the cases that we teach is a classic malpractice case where the divorce lawyer put together a deal where a business, an enormous amount of cash went to the husband, and the wife got the condo. And years later, when she went to sell the condo, she could not pay the taxes that were due on the condo. And the husband, the attorney failed to help her have the ability to support herself and pay the taxes that would be due. And the attorney never warned her that she would be facing the tax obligations. So your question is an excellent question, Jeff, and that is, what happens to these taxes when parties divorce and one party is awarded the property? That person takes on the entire tax obligation, and if there's a capital gains consequence, takes on all of the capital gains taxes. And if it's a residence and each party had that $250,000 exclusion that would be credited or deducted from the capital gains tax, that's reduced It's no longer 500,000 for
Bye-bye.
both of
Yep.
them. Should they sell, it's reduced down to 250. So I know when you're involved in a transaction, you're very good at making sure that your client knows about that consequence. And a family law attorney should also inform their client, hey, if you take this house and you take title to this house, then you're going to be responsible for the entire tax. There's some tax law that says that if we don't award the house in deed and title isn't transferred yet, and one spouse moves out, there is a period of years where they may be able to apply the entire $500,000 exclusion, or deduction. But I'm not a tax attorney, and there's some wriggle room there, but I would often consult with a CPA or a tax attorney to make sure that we can use every possible strategy.
Wow, that's so important for people to know that are going to be in the spot of getting divorced with one spouse staying in the house. I mean, that could be a really huge number where the spouse that is not staying in the house, they don't have to pay any fees, right? Like if they both agree that the value of the house is $1 million, one spouse is basically giving $500,000 to the other one, basically in a settlement, not with any closing cost, any real estate fees, any capital gains taxes paid. So, wow. So that really needs to be accounted for.
That's a really good point that you raised, Jeff. It's a delicate negotiating challenge, because one party might say, I want you to pay me half the closing costs. I'm going to keep the house, but when I sell the house, I'm going to have closing costs. And the other party might say, but you may never sell, and you might not sell for years. Or one party might say, I want you to pay me half of what the capital gains taxes are today. And the other party might say, but we don't know what the house is going to be worth. It might go down in value. You might pass this house on to our kids and never have to pay any tax at all. So it takes some negotiating, and luckily in a divorce, there are 15, 20, 30 issues that we have to resolve. And we try and resolve all of them in context to each other so that each spouse is treated fairly.
Wow, just that one part has so many different potential outcomes and so many different points that need to be agreed upon.
Yes. Same in a real estate transaction that you have, where there are so many issues for you to negotiate, even besides price. Are we including are we including this part of the house, or these improvements, or are we going to have a special warranty, or what's the date of possession? I mean, so what you do takes some delicate balancing as well, but I know you're very good at it, Jeff.
Thank you. Yes, the
Team 805 is very good at hitting all those details.
thank you, Richard. It's from the real estate side. A lot of people assume that once the terms of the offer are agreed upon, that's when all of the negotiations end. And they typically don't end until the day of closing or maybe a day before. Things
Right.
just come up all the time, to your point. Just we can wrap up shortly. Just want to throw a couple of, like if we had this live and there were a bunch of people on the phone, a bunch of people that were asking questions, they would say, well, what if this, what if that? So I have a couple of those for you.
Not unlike a town hall meeting.
Exactly. So if somebody marries and the spouse moves into that person's house, and the person that owned the house is still paying the mortgage, does the spouse that's moving in gain, what kind of interest does the spouse moving into the house gain in the equity and in the appreciation?
Zero interest. Um, so, so if we're getting married and let's say husband and wife are getting married, and husband, let's say wife owns the house. They move into the wife's house. If she pays the payments and the improvements out of her separate property funds, then the husband doesn't gain any interest at all. These are important parts of a premarital agreement that we cover, because what often happens is wife will take community money that they both earn, and she will make the mortgage payments and the improvements. She'll take those monies out of a joint account. When that happens, then husband, non-owning husband, and the community will have a potential interest in the appreciation of the house during the marriage. There's a formula that's not very advantageous to the non-owning spouse, but there is an opportunity to participate in appreciation, or at least get a reimbursement. So that's why we suggest or recommend that there's a premarital agreement or a post-marital agreement that addresses that, because they're often paying for that house or its improvements or upkeep, insurance, taxes, air conditioner, new roof. They're often paying that out of joint funds, and when that happens, it's fair that we share in the appreciation, or that the non-owning spouse participate in those kinds of expenses.
For the same-sex marriage, which we haven't approached, and we've been saying husband and wife a lot, for the same-sex marriage in California that they got married, are the family laws 100% applicable?
Fortunately now, yes, 100% applicable. There was a case years ago when Congress passed a law, the Marriage Act, that said marriage has to be between a man and a woman. And then California passed a law permitting people to be domestic partners, which applied community property laws to same-sex marriages. But more recently, our Supreme Court stepped in and said it's okay for people of the same sex to marry. And since then, now the law is supposed to be blind, and is blind as to the sexual orientation of people getting married. The community law, community property laws, and the family law in California apply equally, whether you're same sex or different sex. Many people are very concerned what might happen in the election, because there are some political interests in the country that would like to reverse that, and would like to make it so that in America only people of different sexes can marry. But right now, same-sex marriage is no different than marriage between heterosexuals. So get out there and vote.
And so I'm going to ask this, even though I think it's already been answered. People that move in with each other, same sex or opposite, if they don't get married and they buy a house together, they just need, and then they go their separate ways. There's no family laws that address that, because there's no common law marriage. So they just need to figure that out. Is that right?
Well,
Unless they have a agreement, which would be a good idea.
it'd be a great idea to have an agreement. That's why you are such a wonderful real estate professional, is because I know you tell people, hey, you can go to a lawyer or lawyers and put an agreement together that clarifies your co-ownership. If the people are not married and they buy a house together, then they're treated just like partners, just like, Jeff, if you and I bought a house together. There's no common law marriage or community property law that applies to them, even though they live together in the house. However, there is this Marvin case that we need to keep in mind. And that Marvin case says, if the people living together split up and one person says, hey, you made a verbal promise to me, and I'm going to enforce it. Most people don't know this, but that verbal promise, if you convince a judge of it, is binding. So if we buy a house together and we move in together and we live together, or we're romantically involved, and then we split up, and I say, wait a minute, you said I could have 70% of the sale proceeds and that we would sell the house immediately if we split up. You said that you would pay the lawyer's fees and the closing fees. You said that I could have the Ferrari if we break up. Even though we're not married and there's no common law marriage and community property laws don't apply to us, the Marvin palimony laws do apply to us. And if I go to court and convince the judge that you made those promises, they are enforceable. And that's the reason why we say, hey, if you're going to live together, let's have a cohabitation agreement. And let's resolve those issues in the cohabitation agreement in case we split up. And a cohabitation agreement's a simple agreement. It's less expensive than a post-marital or a premarital agreement, and we certainly suggest it.
It's great to keep in mind that the Marvin palimony is for people that haven't got married. So there still are going to be applicable laws. And as you discussed with Marvin cases, it's got to be so much more complicated because in that case, there's nothing in writing, or not everything's in writing. And it's a he said, she said, and proving that, and get something in writing, please.
It is, I'll tell you a real kicker. I don't want to overly complicate this, but I think it's very interesting. And maybe you and your vast listening audience would agree that this is interesting. If two people get married, and during the marriage, a spouse says to the other, don't worry, if we get divorced, that rental that we bought together is yours, and the Ferrari is yours. Don't worry, I make that commitment to you. If those people get divorced later, because they were legally married, that promise is not binding, because it's a verbal promise. And our community property laws say that a verbal promise between spouses is not binding. But if those people live together, and during their period of cohabitation, one makes a promise to them, hey, you can have that rental if we split up, and you can have the Ferrari if we split up. I promise you. Between the people that are simply living together, that verbal promise, if proven, is enforceable. So it's really a crazy distinction between being married and not being married and verbal promises.
It really is.
The mystery of our family laws. It's a real mystery, almost as mysterious as our real estate laws.
Are our family laws, did they come over from England in the 1600s, or are they a lot more updated than that?
Our legal system is largely from the English system, yes.
Let's wrap up with potentially one last question.
Okay.
If during the marriage, parents gift a down payment to one of the spouses when they buy a house, what happens to that money should that couple get divorced?
It's a great question. If people buy a house together and they don't have a premarital agreement and they get married, the law says that they get reimbursed for their separate property down payments. They get reimbursed without interest for their separate property contributions to acquiring the house.
Separate property, okay.
Separate property. So if I get married and my parents give me $50,000, and I take that and I say, that's my separate property, I'm gonna use that as my contribution to the down payment. And my wife gets 10,000 from her parents, and we can trace that these are gifts to us as individuals. Then should we get divorced, when we sell the house, I get my 50,000 back, and she gets her 10,000 back. It's called the 2640 reimbursement, and it's without interest. But your question is an excellent question, Jeff, because the problem we have is, what happens if my parents give that $50,000, but they give it to both of us? What happens if they write that check to me, but I put it in a joint account? And then I write a check from the joint account to the escrow office, and now we have some question as to whether that gift was from my parents to me. Was it from my parents to both of us? Or did I commingle it and make it into community property before it went to escrow? So I know that you take great care to do this when you're involved in a transaction. Many realtors don't. So it's very important. If there are gifts going on, we want to address those gifts, and we want to be careful and say, okay, if this $50,000 is being gifted, let's preserve a record. Husband, if you want to remember that this 50,000 was a gift to you, then let's exchange emails, or let's make sure it goes from parents to husband, and husband to escrow, or parents to escrow. But let's make sure that we identify that gift, and whether it's husband's separate property or community property. Important point. I know that Team 805 does a good job in addressing those gift situations.
Thank you.
And I salute Team 805 and you, Jeff, because you do a great job.
Thank you, Richard.
You're welcome.
At the beginning of this recording, we spoke about some incredible similarities that we have in our business. And another similarity we have is, if I have a client that's selling their home and they say, should we disclose this? I have a standard answer for that. My standard answer is, if you're even thinking and wondering if you should disclose it, disclose it. Disclose it. Would it be safe to assume that if somebody says to you, well, I don't know, do you think we should put this in writing? Do you have the same answer, or do you ever recommend somebody not to put something in writing?
Well, you know, I'm an attorney, and I've been doing this a while, so I always recommend let's have a record, and let's put this in writing, and let's make sure that we have a record of what we're doing. So yes, whenever you think about, should I put this in writing, I have the same answer, Jeff, and that is put it in writing. You know, in sailing, when the wind picks up and we're concerned about whether there's too much wind in the sail, and maybe it's difficult to manage the boat, people say, we should reef the sail. We should reduce the amount of sail that's facing the wind. We should reef. And there's what we say in sailing is the question, when should I reef? And the answer is, whenever you think maybe it's a good idea. And it's the same with putting things in writing. As you say, whenever we think it maybe is a good idea to put something in writing, do it.
I'm going to wrap this up, and I think this may sound weird as I first start saying it. They say the best time to prepare for war is during peacetime, right? You don't start doing drills during war when you need to be protecting yourself or advancing. You need to have practiced that before.
You know what they say? Everybody has a plan until they get hit in the face.
Thank you to Mike Tyson for that one. So I think that this is applicable for if somebody ever says, well, everything's going well now, we're in love and we're getting married, or we're already married, and I don't know, it seems like kind of weird to put something in writing. That's the exact time to put it in writing, because when you butt heads, if you get divorced or something goes sideways, that's not the time to put something in writing. At that point, it's too late. So as a public service announcement, even though I'm sure Richard would agree, and I'll eventually let him talk, if there's one takeaway from this time that you spent with us, please get agreements in writing. Richard can help with prenuptials, postnuptials, and also the Marvin Palimony cases. Richard, anything that you want to wrap up with?
You really made a great point, Jeff, and that is maybe that's why premarital agreements so often work and work well, is because we enter into them just before we're getting married and people are in love. And that's my favorite part of my job, is working with people that are in love. But maybe that's why they're successful. It's a putting an agreement together when you're disposed to agree, and enter into that agreement easily. That's a great time to enter into an agreement. So I agree with you 100%.
Richard, somebody watching this is going to want to get a hold of you at some point. What is the best way for somebody to do that?
They can reach me at my website, rfsperlinglaw.com. They can email me at sperlinglaw@hotmail.com. They can phone me at 818-991-0345. I'm out there. I'm on the internet. I'm easy to get a hold of. Almost as easy as it is to contact Jeff Landau and Team 805 if you're interested in buying or selling real estate.
I think it's time for you to co-host this.
Jeff, I've enjoyed this very much. Thank you for the opportunity.
Absolutely. Thank you. And if you're in Westlake Village and you go to the landing, there's a good chance that you're going to see Richard having some coffee or coffee and hot chocolate at Bonnaby.
The coffee's
Richard,
on me.
thank you for joining me. Thank you for providing value to my audience, Richard. Thank you so much.
Thank you, Jeff.